Okay, so magandang gabi sa lahat at ito na naman ang inyong Lolo Ray para sa isa na namang edisyon no, ng ating pagbabasa ng batas. At ngayon ay itutuloy natin yung ating corporation code. Nagtapos tayo dun sa section 38 last time. So ito naman itutuloy natin yung section 39 na ang pinag-uusapan pa rin ay yung powers ng corporation. Section 30, power to deny preemptive right. All stockholders of a stock corporation shall enjoy preemptive right to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings unless such right is denied by the articles of incorporation or an amendment thereto, provided that such preemptive right shall not extend to shares to be issued in compliance with laws requiring stock offerings or minimum stock ownership. Dali, namamatay-matay yan. Minimum stock ownership by the public. Or to shares to be issued in good faith with the approval of the stockholders representing 2/3 of the outstanding capital stock in exchange for needed for corporate purposes or in payment of a previously contracted debt. Okay, so kapangyarihan yun ha. Power. Meron silang power. Lahat na ng stockholders of a stock corporation shall enjoy preemptive right. Okay, preemptive right to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings, sabi nila. Yun nga lamang, unless such right is denied by the articles of incorporation o nung amendment noon. Yun lang naman ang sinasabi niya rito. Section 40, sale or other disposition of assets. Subject to the provisions of existing laws on illegal combinations and monopolies, a corporation may, by a majority vote of its board of directors or trustees, sell, pwede sila magbenta, sell, lease, exchange, mortgage, natumba. Ayan. Mortgage, pledge, or otherwise dispose of all or substantially all of its property assets, including its goodwill, upon such terms and conditions, and for such consideration which may be money, stocks, bonds, or other instruments for the payment of money or other property or consideration as its board of directors or trustees may deem expedient, when authorized by the vote of the stockholders representing at least 2/3 of the outstanding capital stock, or in case of non-stock corporation, by the vote of at least, dali na wala, 2/3, boto daw na at least 2/3 of the members in a stockholders or members meeting duly called for the purpose. Napansin nyo laging sinasabi, boto ng 2/3. Diba? Kung sa stock corporation, boto ng 2/3 of the outstanding capital stock. 2/3 ng may-ari na outstanding capital stock. And yung 2/3 naman kung non-stock corporation yung members nito. Itong botohan na to ay mangyayari sa isang stockholders meeting na duly called for this purpose. Written notice of the proposed action and of the time and place of the meeting shall be addressed to each stockholder or member at his place of residence as shown on the books of the corporation and deposited to the addressee in the post office with postage prepaid or served personally, provided that any dissenting stockholder may exercise his appraisal right under the conditions provided in this code. Okay. A sale or other disposition shall be deemed to cover substantially all the corporate property and assets if thereby the corporation will be rendered incapable of continuing the business or accomplishing the purpose for which it was incorporated. After such authorization or approval by the stockholders or members, the board of directors or trustees may, nevertheless, in its discretion, abandon such sale, lease, exchange, mortgage, pledge, or other disposition of property and assets subject to the rights of third parties under any contract relating thereto without further action or approval by the stockholders or members. So, pwedeng magbenta ng ari-arian ang isang korporasyon, no? Pwede sila magbenta ng ari-arian. Kung ito isasang-ayunan ng 2/3, di ba? Yung sinabi kanina. Basta sinang-ayunan siya ng 2/3 ng may-ari, di ba? Yung majority ng may-ari ng outstanding capital stock. Yung magulo yung sinasabi ko eh. Basta inaprubahan ng 2/3 nung the majority comprising of 2/3 of the owners of the outstanding capital stock, pwede sila magbenta ng assets. Nothing in this section is intended to restrict the power of any corporation without the authorization by the stockholders or members to sell, lease, exchange, mortgage, pledge, or otherwise dispose of any of its property and assets if the same is necessary in the usual and regular course of business of said corporation, or if the proceeds of the sale or other disposition of such property and assets be appropriated for the conduct of its remaining business. In non-stock corporations where there are no members with voting rights, the vote of at least a majority of the trustees in office will present authorization for the corporation to enter into any transaction authorized by this section. So mga non-stock corporations, ito kadalasan mga foundations ito. Kapag walang mga member daw with voting rights, the vote of at least a majority ng mga trustees. Di ba? Yun ang sabi. Pero ang magic number is yung 2/3, di ba? Section 41, power to acquire own shares. A stock corporation shall have the power to purchase or acquire its own shares for a legitimate corporate purpose or purposes, including but not limited to the following cases, provided that the corporation has unrestricted retained earnings in its books to cover the shares to be purchased or acquired. So ito pwede raw to basta may kapangyarihan sila na mamili ng kanilang own shares. Okay? Kung basta lamang itong korporasyon na to ay merong unrestricted retained earnings in its books to cover the shares to be purchased. Sabihin may pambayad. Number 1, to eliminate fractional shares arising out of stock dividends. Number 2, to collect or compromise unindebtedness to the corporation arising out of unpaid subscription in a delinquency sale and to purchase delinquent shares sold during said sale. And number 3, to pay dissenting or withdrawing stockholders. Yung mga nagwi-withdraw na sila. Sabihin na nating paalis ng mga stockholders entitled to payment for their shares under the provisions of this code. Okay. Section 42, power to invest corporate funds in another corporation or business or for any other purpose. Subject to the provisions of this code, a private corporation invest its funds in any other corporation or business or for any purpose other than the primary purpose for which it was organized when approved by a majority of the board of directors or trustees and ratified by the stockholders representing at least 2/3 of the outstanding capital stock. So ito na naman, kailangan nila ng ratifikasyon ng 2/3 of the outstanding capital stock. So lilinawin ko lang sa pagkaintindi ko, kung kunwari isa mo lang, 10 kayong board of director, isa mo lang. Pero yung halaga ng outstanding capital stock na nasa iyo comprises of 2/3, makapangyayari yung gusto mo. Okay? Or by at least 2/3 of the members in case of non-stock corporations at the stockholders or members meeting duly called for the purpose. Written notice of the proposed investment and the time and place of the meeting shall be addressed to each stockholder or member at his place of residence as shown on the books of the corporation and deposited to the addressee in the post office with postage prepaid or served personally. Provided that any dissenting stockholder shall have appraisal right as provided in this code. Mamaya siguro baka magpunta rin tayo sa appraisal right. Pagkakaintindi ko doon yung karapatan na i-appraise niya yung halaga. Parang gano'n. Okay. Provided, however, that where the investment by the corporation is reasonably necessary to accomplish its primary purpose as stated in the Articles of Incorporation, the approval of the stockholders or members shall not be necessary. Section 43, power to declare dividends. Okay. Ito yung gustong-gusto ng isang stockholder, di ba? The board of directors of a stock corporation may declare dividends out of the unrestricted retained earnings which shall be paid in cash, in property, or in stock to all stockholders on the basis of outstanding stock held by them. Provided that any cash dividends due on delinquent stock shall first be applied to the unpaid balance on the subscription plus costs and expenses, while stock dividends shall be withheld from the delinquent stockholder until his unpaid subscription is fully paid. Provided further that no stock dividends shall be issued without the approval of stockholders representing not less than 2/3 of the outstanding capital stock at a regular or special meeting duly called for the purpose. Stock corporations are prohibited from retaining surplus profits in excess of 100% of their paid-in capital stock. So bawal pala yun, ano? Pinagbabawal ang mga stock corporations na ma-retain sa kanila yung mga sobrang kita na lalagpas sa 100% of their paid-in capital stock, no? Yun nga lamang except when justified by definite corporate expansion projects or programs approved by the directors. So pwede itong i-bypass ng board of directors. Number 2, when the corporation is prohibited under any loan agreement with any financial institution or creditor, whether local or foreign, from declaring dividends without consent, and such consent has not yet been secured. Or ikatatlo, number 3, when it can be clearly shown that such retention is necessary under special circumstances obtaining in the corporation, such as when there is need for special reserve for probable contingencies. Hirap na may acid. Okay, so ulitin natin, stock corporations ay pinagbabawalan. Okay, from retaining surplus profits in excess of 100%. Okay, in excess of 100% of their paid-in capital stock, maliban na lamang sa ating mga nabanggit. Sa retained, balikan nga natin yung isa, doon kinukuha yung dividendo eh. Sa unrestricted retained earnings, okay, doon kinukuha yung dividendo. So kailangan hindi sobra doon sa 100% of their paid-in capital stock yung kita ninyo. Otherwise, siguro dividendo na yun, ano? So malalaki ang dividendo ng board, no? Kung malaki ang kita nila. Kasi anything in excess, sa pagkaintindi ko lang anything in excess of 100% of their paid-in capital stock ay bawal daw na i-retain eh. Ako lang, medyo naguguluhan tayo, pero at least nabasa naman na natin yung batas, ano? Section 44, the power to enter into management contract. No corporation shall conclude a management contract with another corporation unless such contract shall have been approved by the board of directors and by stockholders owning at least the majority of the outstanding capital stock, or by at least the majority of the members base of a non-stock corporation of both the managing and the managed corporation at a meeting duly called for the purpose. Provided that number 1, where a stockholder or stockholders representing the same interest of both the managing and the managed corporations own or control more than 1/3 of the total outstanding capital stock entitled to vote of the managing corporation. Okay, number 2, where a majority of the members of the board of directors of the managing corporation also constitute a majority of the members of the board of directors of the managed corporation, then the management contract must be approved by the stockholders of the managed corporation owning at least 2/3 of the total outstanding capital stock entitled to vote, or by at least 2/3 of the members in the case of a non-stock corporation. No management contract shall be entered into for a period longer than 5 years for any one term. So ito, merong isang another corporation na minamanage nitong korporasyon, no? The provisions, hirap magbasa sa computer. The provisions of the next preceding paragraph shall apply to any contract whereby a corporation undertakes to manage or operate all or substantially all of the business of another corporation, whether such contracts are called service contracts, operating agreements, or otherwise. Provided, however, that such service contracts or operating agreements which relate to the exploration, development, exploitation, or utilization of natural resources may be entered into for such periods as may be provided by the pertinent laws or regulations. Section 45, ultra vires acts of corporation. Okay. No corporation under this oath shall possess or exercise any corporate powers except those conferred by this code or by its articles of incorporation, except such as are necessary or incidental to the exercise of the powers so conferred. Yun yung ultra vires acts of the corporation, necessary or incidental. Hindi man nakasaad pinagkaloob under this code directly, hindi man nakasaad sa kanilang articles of incorporation, pero yung kanilang mga acts na yon necessary or incidental to the exercise ng kanilang kapangyarihan na ipinagkaloob ng batas. Okay? So medyo magulo, medyo mahirap unawain ng korporasyon kasi ang tingin ng batas sa kanya, isa siyang juridical personality. Meron siyang sariling personality sa batas. Like you and me. Pero syempre tayo, natural persons tayo eh. Sila juridical, ang korporasyon ay may juridical entity na mayroong personality sa batas. Pwede magmay-ari. Di ba sinabi, pwedeng magmay-ari o magbenta ng kanilang mga ari-arian. Section 46. Okay. Okay, yung Title 5 ay nagsisimula sa Section 46. Pag-uusapan natin yung bylaws. Okay. Kanina nabasa na natin yung Articles of Incorporation. Ngayon naman yung adoption of bylaws. Every corporation formed under this code must, within 1 month after receipt of official notice of the issuance of its certificate of incorporation by the SEC, adopt a code of bylaws for its government not inconsistent with this code. Dapat alinsunod sa corporation code yung bylaws na i-adapt ninyo. For the adoption of bylaws in the corporation, the affirmative vote of the stockholders representing at least the majority of the outstanding capital stock or of at least the majority of the members in case of non-stock corporations shall be necessary. The bylaws shall be signed by the stockholders or members voting for them and shall be kept in the principal office of the corporation subject to the inspection of the stockholders or members during office hours. So dito nakalagay yung kung paano nila i-govern yung korporasyon, no? Paano pamamahalaan. Ito yung bylaws, di ba? Kumbaga sa isang batas, ito na siguro yung implementing rules and regulations, no? Okay. At ilalagay daw itong bylaws daw na i-adapt, okay? It shall be signed by the stockholders or members na bumoboto para sa kanila at ilalagay ito sa principal office of the corporation at pwede itong inspeksyonin ng mga stockholders during office hours. A company thereof duly certified to by a majority of the directors or trustees, countersigned by the Secretary of the Corporation, shall be filed with the Securities and Exchange Commission, which shall be attached to the original Articles of Incorporation. So magkakasama yan. Pagsasama-samahin yan ng SEC. Notwithstanding the provisions of the preceding paragraph, bylaws may be adopted and filed prior to incorporation. In such case, such bylaws shall be approved and signed by all the incorporators and submitted to the SEC together with the articles of incorporation. So yun pala, no? Pwede naman palang i-adopt at i-file ito bago yung incorporation o yung pagkabuo ng iyong korporasyon. So pag ganun ang gagawin mo, yung bylaws mo shall be approved and signed by all the incorporators and submitted to the Securities and Exchange Commission kasama ng Articles of Incorporation. So maganda siguro sama-sama na. Pero ang sinasabi niya, yung normal, sa period ng 1 month 'Di ba? Within 1 month, pagkatanggap mo no articles of incorporation mo, ka na mag-adapt ng bylaws mo. Pero pwede rin naman palang mag-adapt ka ng bylaws mo, isabay mo na siyang ipasa kasama ng iyong articles of incorporation. In all cases, bylaws shall be effective only upon the issuance by the SEC of a certification that the bylaws are not inconsistent with this code. Susuriin ito ng Securities and Exchange Commission, tapos titignan nila kung alinsunod ba ito sa nilalaman ng Corporation Code. The SEC shall not accept for filing the bylaws or any amendment thereto of any bank, banking institution, building and loan association, trust company, insurance company, public utility, educational institution, or other special corporations governed by special laws, unless accompanied by a certificate of the appropriate government agency to the effect that such bylaws or amendments are in accordance or alinsunod sa batas. Section 47, Contents of Bylaws. Subject to the provisions of the Constitution, this code, other special laws, and the articles of incorporation, a private corporation may provide in its bylaws for. So ito yung nilalaman niya. Number 1, the time, place, and manner of calling and conducting regular or special meetings of the directors or trustees. Number 2, the time and manner of calling and conducting regular or special meetings of the stockholders or members. Number 3, the required quorum in meetings of stockholders or members and the manner of voting therein. So ano ba yung magko-constitute ng quorum? Kailan ba natin masasabi na may quorum? At kahit maming absent, pwede pa rin natin ituloy ito. Yun yung ibig sabihin nun. Number 4, the form for proxies of stockholders and members and manner of voting for them. Number 5, the qualifications, duties, and compensation of directors or trustees, officers, and employees. Number 6, the time for holding the annual election of directors, of trustees, and the mode of or manner of giving notice thereof. Number 7, the manner of election or appointment and the term of office of all officers other than directors or trustees. Number 8, the penalties for violation of the bylaws. Number 9, in the case of stock corporations, the manner of issuing stock certificates. And number 10, such other matters as may be necessary for the proper or convenient transaction of its corporate business and affairs. Lagi natin tatandaan, pag banking institution daw, o yung mga public utility something, ganyan, insurance, kailangan daw yung pag-aamyendahan yung bylaws. Merong kaakibat na certificate galing sa proper government agency. Section 48, amendments to bylaws. The board of directors or trustees by a majority vote thereof, and the owners of at least a majority of the outstanding capital stock, or at least a majority of the members of a non-stock corporation, at a regular or special meeting duly called for the purpose, may amend or repeal any bylaws or adopt new bylaws. The owners of 2/3 of the outstanding capital stock or 2/3 of the members in a non-stock corporation may delegate to the board of directors or trustees the power to amend or repeal any bylaws. Okay? Pwede nilang i-delegate yun sa board of directors. The power to amend or repeal bylaws or adopt new bylaws. Provided that any power delegated to the board of directors or trustees to amend or repeal any bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of the outstanding capital stock or a majority of the members in non-stock corporations shall so vote at a regular or special meeting. Okay. So kung boboto itong mga majority na ito, mawawala ng kapangyarihan yung pag-delegate nila doon sa board of directors. Kasi andun sila boboto sila sa mismong meeting whether itong meeting na to ay regular or special. Whenever any amendment or new bylaws are adopted, such amendment or new bylaws shall be attached to the original bylaws in the office of the corporation, and a copy thereof, duly certified under oath by the corporate secretary and the majority of the directors or trustees, shall be filed with the Securities and Exchange Commission, the same to be attached to the original articles of incorporation and original bylaws. The amended or new bylaws shall only be effective upon the issuance by the Securities and Exchange Commission of a certification that the same are not inconsistent with this code. So kailangan magkaroon ng laging may say ang SEC na okay, alinsunod sa corporation code yung inyong bylaws. Title 6, meetings. Kinds of meetings, Section 49. Meetings of directors, trustees, stockholders, or members may be regular or special. Dalawa lamang, regular or special. Section 50, regular and special meetings of stockholders or members. Regular meetings of stockholders or members shall be held annually on a date fixed in the bylaws, or kung hindi daw ito nakasaad, or if not so fixed, on any date in April of every year as determined by the Board of Directors or Trustees. Provided that written notice of regular meetings shall be sent to all stockholders or members of record at least 2 weeks prior to the meeting, unless a different period is required by the bylaws. Siguro ako at least 1 week. Kung ako yung Board of Director, at least 1 week niya ipadala sa akin. Special meetings of stockholders or members shall be held at any time deemed necessary or as provided in the bylaws, provided, however, that at least 1 week written notice shall be sent to all stockholders or members unless otherwise provided in the bylaws. Notice of any meeting may be waived expressly or impliedly by any stockholder or member. Whenever for any cause no person authorized to call a meeting, the SEC, upon petition of a stockholder or member on a showing of good cause, therefore may issue an order to the petitioning stockholder or member directing him to call a meeting of the corporation by giving proper notice required by this code or by the bylaws. The petitioning stockholder or member shall preside thereat until at least the majority of the stockholders or members present have been chosen one of their member as presiding officer. Okay, so pwedeng magtawag. Usually, ginagawa lang to siguro pag kailangan. Na magpe-petition siya sa SEC na maglabas po kayo ng order SEC na magpatawag ng stockholders meeting, no? Section 51, place and time of meetings of stockholders or members. Stockholders or members meetings, whether regular or special, shall be held in the city or municipality where the principal office of the corporation is located, and if practicable, in the principal office of the corporation, provided that Metro Manila shall, for purposes of this section, be considered a city or municipality. Notice of meetings shall be in writing, and the time and place thereof stated therein. All proceedings had and any business transacted at any meeting of the stockholders or members, if within the powers or authority of the corporation, shall be valid, even if the meeting be improperly held or called, provided all the stockholders or members of the corporation are present or duly represented at the meeting. Section 52, yung quorum in meetings. Unless otherwise provided for in this code or in the bylaws, a quorum shall consist of the stockholders representing a majority of the outstanding capital stock or a majority of the members in the case of non-stock corporations. Mabalik ako sa example ko kanina na hindi naman ako sure, pero paano kung ako lang yung present pero ako yung nagre-represent ng 2/3 of the outstanding capital stock? E di may quorum ako by myself. Ganun ba yun? Tingin ko ganon. Ewan ko Section 53, regular and special meetings of directors or trustees. Regular meetings of the Board of Directors or Trustees of every corporation shall be held monthly unless the bylaws provide otherwise. So ito ang regular meeting ng mga direktor o ng mga Board of Trustee pagka non-stock, no? Special meetings of the Board of Directors or Trustees may be held at any time upon the call of the President, or as provided in the bylaws. So pag nagtawag yung presidente, pwede. Meetings of directors or trustees of corporations may be held anywhere in or outside of the Philippines unless the bylaws provide otherwise. Note, so ito, sandali, mabalik tayo. Regular meeting ito, sinasabi rito. Regular meeting. Ay, ang hirap naman. Wait lang. Okay, regular meetings shall be held annually. Ang sabi kanina, annually. Ngayon, sabi, ang place and time, stockholders meeting, sabi, whether regular or special, shall be held in the city or municipality, principal place of business. Ngayon naman sabi, regular meetings of board of directors shall be held monthly. Sandali, ano ba yung... okay, sorry. Stockholders meeting, sabi na annually yun. At gaganapin yun sa principal place of business. Ito naman yung sinasabi rito, board of directors or trustees of every corporation shall be held monthly unless the bylaws provide otherwise. Actually, nalilito ako. Ang iniisip ko, pag stockholder ka, board of trustees ka, hindi. Pinagbobotohan yun para magkaroon ng, mag-create. Sino yung mga board of directors, di ba? So, yung regular and special meetings of directors or trustees shall be monthly unless the bylaws provide otherwise. Special board of directors or trustees may be held at any time upon the call of the president, yun, as provided in the bylaws. Ayan. Meetings of directors or trustees of corporations may be held, sabi nila, anywhere, pagka board of directors meeting, anywhere in or outside of the Philippines unless the bylaws provide otherwise. Notice of regular or special meetings stating the date, time, and place of the meeting must be sent to every director or trustee at least 1 day prior to the scheduled meeting unless otherwise provided by the bylaws, period. A director or trustee may waive this requirement either expressly or impliedly. Lalo na siguro kung chicks niya naman yung secretary, no? Siya na mag-i-inform sa akin. Ganun kaya yung tatay ko, no? Okay. Section 50 shall preside at meetings. The President shall preside at all the meetings of the directors or trustees, as well as of the stockholders or members, unless the bylaws provide otherwise. Section 50. So, sa meeting, stockholders meeting, Presidente ang mag-preside as a general rule. Pagdating naman sa meetings ng Board of Directors, which is yung ginaganap monthly, dun din, President ang magpe-preside as a general rule. Section 55, right to vote of pledgers, mortgagors, and administrators. In case of pledged or mortgaged shares in stock corporations, the pledger or mortgagor shall have the right to attend the vote at meetings of stockholders unless the pledgee or mortgagee is expressly given by the pledger or mortgagor such right in writing, which is recorded on the appropriate corporate books. Okay. Sabi lang naman dito, yung nagpe-pledge o yung nagsasanla ng kanilang mga stock, may karapatan pa rin silang umattend sa meeting. Unless nga lamang yung pinagsanlaan o yung pinag-pledgean ay binigyan ng pledger nung nagsasanla o nung pledger nung nag-pledge or ng mortgagor yung nagsanla ng karapatan para yung pinagsanlaan nila ang magpunta sa mga board meeting at yun shall be recorded on the appropriate corporate books. Executors, administrators, receivers, and other legal representatives duly appointed by the court may attend and vote in behalf of the stockholders or members without need of any written proxy. Section 56, voting in case of joint ownership of stock. In case of shares of stock owned jointly by two or more persons, in order to vote the same, the consent of all the co-owners shall be necessary unless there is a written proxy signed by all the co-owners authorizing one or some of them or any other person to vote such share or shares, provided that when the shares are owned in an and or capacity by the holders thereof, any one of the joint owners can vote said shares or appoint a proxy therefore. So may nakalagay daw na and or. Section 57, voting right for treasury shares. Treasury shares shall have no voting right as long as such shares remain in the treasury. Walang karapatang bumoto itong treasury shares. Section 58, proxies. Stockholders and members may vote in person or by proxy in all meetings of stockholders or members. Proxies shall in writing signed by the stockholder member and filed before the scheduled meeting with the corporate secretary. Unless otherwise provided in the proxy, it shall be valid only for the meeting for which it is intended. No proxy shall be valid and effective for a period longer than 5 years at any one time. Section 59, voting trusts. One or more stockholders of a stock corporation may create a voting trust for the purpose of conferring upon a trustee or trustees. Doon niya ilalagay. Ilalagay niya sa kamay ng mga trustee or trustees yung karapatan or the right to vote and the other rights pertaining to the shares for a period not exceeding 5 years at any time. So, pwede pala silang gumawa ng voting trust. Diba? Provided that in the case of a voting trust specifically required as a condition in a loan agreement, said voting trust may be for a period exceeding 5 years but shall automatically expire upon full payment of the loan. A voting trust agreement must be in writing and notarized and shall specify the terms and conditions thereof. A certified copy of such agreement shall be filed with the corporation and with the Securities and Exchange Commission. Otherwise, said agreement is ineffective and unenforceable. The certificate or certificates of stock covered by the voting trust agreement shall be cancelled and new ones shall be issued in the name of the trustee or trustees, stating that they are issued pursuant to said agreement. In the books of the corporation, it shall be noted that the transfer in the name of the trustee or trustees is made pursuant to said voting trust agreement. The trustee or trustees shall execute and deliver to the transferors voting trust certificates, which shall be transferable in the same manner and with the same effect as certificates of stock. Uy, parehas ha? Same manner, same effect. The voting trust agreement filed with the corporation shall be subject to examination by any stockholder of the corporation in the same manner as any other corporate book or record. Kasi karapatan naman yan ng bawat stockholder ng isang korporasyon na mag-examine ng corporate records. So may karapatan din siyang basisiin ang voting trust agreement provided that both the transferor and the trustee or trustees may exercise the right of inspection of all corporate books and records in accordance with the provisions of this code. Any other stockholder may transfer his shares to the same trustee or trustees upon the terms and conditions stated in the voting trust agreement and thereupon shall be bound by all the provisions of said agreement. Okay. No voting trust agreement shall be entered into for the purpose of circumventing law against monopolies and illegal combinations in restraint of trade or used for purposes of fraud. Unless expressly renewed, the rights granted in a voting trust agreement shall automatically expire at the end of the agreed period, and the voting trust certificates as well as the certificates of stock in the name of the trustee or trustees shall thereby be deemed cancelled. Okay, pag natapos na yung period, makakansela na yung stock certificates ng mga trustees and new certificates of stock shall be reissued in the name of the transferors. The voting trustee or trustees may vote by proxy unless the agreement provides otherwise. Okay. Ay, ano ba yan? Hirap naman ito. Okay, sandali nga, nahihirapan na ako eh. Hanapin ko nga yung mouse ko. At magbe-break lang din ako, ako'y magbabalik. Okay, so magtungo na tayo sa Title 7. Stocks and stockholders. Okay. Sisimula ang Title 7 sa Section 60. Corporation Code pa rin, ha? Section 60, subscription contract. Any contract for the acquisition of an issued stock in an existing corporation or a corporation still to be formed shall be deemed a subscription within the meaning of this title, notwithstanding the fact that the parties refer to it as a purchase or some other contract. Okay. Bawat kontrata raw sa pagkuha ng unissued stock sa isang korporasyon shall be deemed a subscription. Okay. Section 61, pre-incorporation subscription. A subscription for shares of stock of a corporation still to be formed shall be irrevocable for a period of at least 6 months from the date of subscription unless all of the other subscribers consent to the revocation or unless the incorporation of said corporation fails to materialize, hindi natuloy, within said period or within a longer period as may be stipulated in the contract of subscription. Provided that no pre-incorporation subscription may be revoked after the submission of the articles of incorporation to the SEC. Okay? Section 62, considering for stocks. Stocks shall not be issued for consideration less than the par or issued price thereof, period. Consideration for the issuance of stock may be any or a combination of any two or more of the following. Number 1, actual cash paid to the corporation. Okay, ibig nila kasi sabihin dito, kailangan may kapalit. Para bigyan ka ng stock, kailangan merong consideration. Number 1, actual cash paid to the corporation. Number 2, property, tangible or intangible, actually received by the corporation and necessary or convenient for its use and lawful purposes at a fair valuation equal to the par or issued value of the stock issued. Number 3, labor performed for or services actually rendered to the corporation. Number 4, previously incurred indebtedness of the corporation. Dating may utang sa'yo yung korporasyon, no? Number 5, amounts transferred from unrestricted retained earnings to stated capital. And number 6, outstanding shares exchanged for stocks in the event of reclassification or conversion. Where the consideration is other than actual cost of copyrights, the valuation thereof shall initially be determined by the incorporators or the board of directors subject to approval by the SEC. Shares of stock shall not be issued in exchange for promissory notes or future service. The same considerations provided for in this section, insofar as they may be applicable, may be used for the issuance of bonds by the corporation. The issued price of no par value shares may be fixed in the articles of incorporation or by the board of directors pursuant to authority conferred upon it by the articles of incorporation or the bylaws, or in the absence thereof by the stockholders representing at least a majority of the outstanding capital stock at a meeting duly called for the purpose. Section 63, Certificate of Stock and Transfer of Shares. The capital stock of stock corporations shall be divided into shares for which certificates signed by the President or Vice President, countersigned by the Secretary or Assistant Secretary, and sealed with the seal of the corporation shall be issued in accordance with the bylaws. Shares of stock so issued are personal property and may be transferred by delivery of the certificate or certificate endorsed by the owner or his attorney in fact or other person legally authorized to make the transfer. No transfer, however, shall be valid except as between the parties until the transfer is recorded in the books of the corporation, showing the names of the parties to the transaction, the date of the transfer, the number of the certificate or certificates, and the number of shares transferred. No shares of stock against which the corporation holds any unpaid claim shall be transferable in the books of the corporation. Section 64, Issuance of Stock Certificates. No certificate of stock shall be issued to a subscriber until the full amount of his subscription, together with the interest and expenses in case of delinquent shares, if any is due, has been paid. So, kailangan bayaran mo ng buong buo. Kunwari, namili ka ng stock, nabayaran mo siya ng buong buo bago ka isyuhan ng certificate of stock. Section 65, Liability of Directors for Watered Stocks. Any director or officer of a corporation consenting o pumapayag sila to the issuance of stocks for a consideration less than its par or issued value, or for a consideration in a form other than cash, valid in excess of its fair value, or who, having knowledge thereof, does not forthwith express its objection in writing and file the same with the corporate secretary, shall be solidarily liable with the stockholder concerned to the corporation and its creditors for the difference between the fair value received at the time of issuance of the stock and the par or issued value of the same. So yung mga watered stocks, ito yung mga binibenta ng mas mababa sa kanyang nakatakdang par value, no? Section 66, so dapat pala kung isa kang stockholder, no? Hindi, kung isa ka sa director or officer ng korporasyon, kailangan i-express mo yung objection mo in writing at naka-file yun doon sa corporate secretary, no? Para wala kang kinalaman doon kung bahala sila. Ayaw yung sumunod sa akin, ayaw yung makinig, mayabang kayo, bahala kayo, o basta ako nag-object, ang liable dyan. Section 66, Interest on Unpaid Subscriptions. Subscribers for stock shall pay to the corporation interest on all unpaid subscriptions from the date of subscription, if so required by and at the rate of interest fixed in the bylaws. If no rate of interest is fixed in the bylaws, such rate shall be deemed to be the legal rate. Section 67, Payment of Balance of Subscription. Subject to the provisions of the Contract of Subscription, the Board of Directors of any stock corporation may at any time declare due and payable to the corporation unpaid subscriptions to the capital stock and may collect the same or such percentage thereof, in either case with accrued interest, kung meron man, if any, as it may deem necessary. Payment of any unpaid subscription or any percentage thereof, together with the interest accrued, kung meron man, shall be made on the date specified in the contract of subscription or on the date stated in the call made by the board. Failure to pay on such date shall render the entire balance due and payable and shall make the stockholder liable for interest at the legal rate on such balance unless a different rate of interest is provided in the bylaws computed from such date until fulfillment. Okay. Sana ako? Computed from such date until full payment. Yun ang ibig sabihin, hindi fulfillment. If within 30 days from the said date, no payment is made, all stocks covered by said subscription shall thereupon become delinquent and shall be subject to sale as herein after provided unless the board of directors orders otherwise. Okay. Okay. So, kailangan pag namili ka ng stock, ganun lang kasimple. Bayaran mo ng buo. Yun ang pinakamaganda sa takdang oras na sinabi. Para hindi magka-problema kasi magiging delinquent siya eh. Sabi rito eh, if within 30 days from the said date, no payment is made, lahat ng stocks na covered ng subscription na hindi fully paid shall thereupon become delinquent and shall be subject to sale. Tungo na tayo dito sa delinquency sale. Mahaba ito mga to ah. Section 68, delinquency sale. The board of directors may, by resolution, order the sale of delinquent stock and shall specifically state on due on each subscription plus all accrued interest and the date, time, and place of the sale which shall not be less than 30 days nor more than 60 days from the date the stocks become delinquent. Okay. May period, ano? Not less than 30 days nor more than 60 days from the date na maging delinquent siya. Notice of said sale with a copy of the resolution shall be sent to every delinquent stockholder, either personally or by registered mail. The same shall furthermore be published once a week for 2 consecutive weeks in a newspaper of general circulation in the province or city where the principal office of the corporation is located, para malaman ng taong bayan na nagbebenta sila ng stocks, no? So, unless the delinquent stockholder pays to the corporation on or before the date specified for the sale of the delinquent stock, the balance due on the subscription plus accrued interest, cost of advertisement, and expenses of sale, or unless the board of directors otherwise orders, said delinquent stock shall be sold at public auction to such bidder who shall offer to pay the full amount of the balance on the subscription together with accrued interest, cost of advertisement, and expenses of sale for the smallest number of shares or fraction of a share. The stock so purchased shall be transferred to such purchaser in the books of the corporation, and a certificate for such stock shall be issued in his favor. The remaining shares, kung meron man, shall be credited in favor of the delinquent stockholder who shall likewise be entitled to the issuance of a certificate of stock covering such shares. Should there be no bidder at the public auction who offers to pay the full amount of the balance on the subscription together with accrued interest, costs of advertisement, and expenses of sale for the smallest number of shares or fraction of a share, the corporation may, subject to the provisions of this code, bid for the same. So, pwede yung corporation ang magbid. And the total amount due shall be credited as paid in full in the books of the corporation. Title to all the shares of stock covered by the subscription shall be vested in the corporation as treasury shares. Okay. So, sabihin na sa madaling salita, no? And may be disposed of by said corporation in accordance with the provisions of this code. Sa madaling salita, merong delinquent share. Okay? Tapos sabihin na natin, korporasyon din ang bumili noon, so mapupunta siya sa treasury shares. At pwede pa rin naman siya dispose ng korporasyon sa ibang paraan na naaayon sa corporation code. Ay, nako, ang haba pa nito. Okay, sandali. Nasaan na ako? Ayun, delinquent. Section 68. Section 68. Okay. Section 69. when sale may be questioned. No action to recover delinquent stock sold can be sustained upon the ground of irregularity or defect in the notice of sale or in the sale itself of the delinquent stock unless the party seeking to maintain such action first pays or tenders to the party holding the stock the sum for which the same was sold with interest from the date of sale at the legal rate. And no such action shall be maintained unless it is commenced by the filing of a complaint within 6 months from the date of the sale. Okay, Section 70, Court Action to Recover Unpaid Subscription. Nothing in this code shall prevent the corporation from collecting by action in a proper court, in a court of proper jurisdiction, the amount due on any unpaid subscription with accrued interest, cost, and expenses. So, pwedeng habulin ng korporasyon doon sa namimiling stockholder yung kanyang mga hindi pa binabayaran with accrued interest, costs, and expenses. Iahabla niya para magbayad dun sa balance niya sa pagbili ng stock. Section 71, effect of delinquency. No delinquent stock shall be voted for for be entitled. Ang dami namang typo nito. No delinquent stock shall be voted or be entitled to vote or to representation at any stockholders' meeting, nor shall the holder thereof be entitled to any of the rights of a stockholder except the right to dividends in accordance with the provisions of this code until and unless he pays the amount due on his subscription with accrued interest and the costs and expenses of advertisement, if any, o kung meron man. Okay, so yun ang epekto ng delinquency. Section 72, Rights of Unpaid Shares. Holders of subscribed shares not fully paid, which are not delinquent, shall have all the rights of a stockholder. Hindi naman siya delinquent eh. Hindi pa lang nababayaran pero within the bounds of the rules siya. Diba? Section 73, Lost or Destroyed Certificates. The following procedure shall be followed for the issuance by a corporation of new certificates of stock in lieu of those which have been lost, stolen, or destroyed. Uy, ganito pala ang ginagawa sa mga nawawalang stock certificates. Number 1, the registered owner of a certificate of stock in a corporation or his legal representative shall file with the corporation an affidavit in triplicate setting forth, if possible, the circumstances as to how the certificate was lost, stolen, or destroyed, the number of shares represented by such certificate, the serial number of the certificate, and the name of the corporation which issued the same. He shall also submit such other information and evidence which he may deem necessary. Okay? Number 2, after verifying the affidavit and other information and evidence with the books of the corporation, said corporation shall publish a notice in a newspaper of general circulation, published in the place where the corporation has its principal office, once a week for 3 consecutive weeks, at the expense of the registered owner of the certificate of stock which has been lost, stolen, or destroyed. The notice shall state the name of said corporation, the name of the registered owner, and the serial number of said certificate, and the number of shares represented by such certificate, and that after the expiration of 1 year from the date of the last publication, if no contest has been presented to said corporation regarding said certificate of stock, the right to make such contest shall be barred, and said corporation shall cancel in its books the certificate of stock which has been lost, stolen, or destroyed, and issue in lieu thereof new certificate of stock unless the registered owner files a bond or other security in lieu thereof as may be required, effective for a period of 1 year, for such amount and in such form and with such sureties as may be satisfactory to the board of directors, in which case a new certificate may be issued even before the expiration of the 1 year period provided herein. Provided that if a contest has been presented to said corporation or if an action is pending in court regarding the ownership of said certificate of stock which has been lost, stolen, or destroyed, The issuance of new certificate of stock in lieu thereof shall be suspended until the final decision by the court regarding the ownership of said certificate of stock which has been lost, stolen, or destroyed. Except in case of fraud, bad faith, or negligence on the part of the corporation and its officers, no action may be brought against any corporation which shall have issued certificate of stock in lieu of those lost, stolen, or destroyed pursuant to the procedure above described. Okay. Okay Okay, so ganun lang pala yun. Kung meron ka nawawalang certificate of stock, magpa-file ka sa korporasyon, an affidavit in triplicate, ilalagay mo doon kung paano nawala, nasira yung stock mo. Okay. Pangalawa nun, i-verify. Tapos, pagka na-verify ka na yun, okay, yung korporasyon ay magpa-publish ng notice sa newspaper for 3 consecutive weeks at the expense. Kaya dapat ingatan mo yung stock mo, no? Kasi at the expense of the registered owner. So kung nawala yung stock mo, gastos mo yung pagpapublish ng korporasyon. Di ba? So ang hirap, di ba? Gastos mawalan. Kaya dapat nakatabi ang iyong mga certificate of stocks. So magbe-break lang ako. Maya-maya pupunta na tayo sa Title 8. At subukan natin tapusin hanggang Section 75. Okay? Title 8 tayo eh. O kung hanggang saan tayo aabot. Sige. Sige, break lang ako. Okay. Okay, narito na tayo sa title. Ano ba yan? Sige, para kunwari mic, no? Okay, narito na tayo sa title 8. Section 4. Section 74. Books to be kept. Stock transfer agent. Every corporation shall keep and carefully preserve at its principal office a board of all business transactions and minutes of all meetings of stockholders or members or of the board of directors or trustees, in which shall be set forth in detail the time and place of holding the meeting, how authorized, the notice given, whether the meeting was regular or special, if special, its object, those present and absent, and every act done or order done at the meeting. Upon the demand of any director, trustee, stockholder, or member, the time when any director, trustee, stockholder, or member entered or left the meeting must be noted in the minutes. And on a similar demand, the yeas, yan yung mga yes, and nays, ito yung mga no, must be taken on any motion or proposition and the record thereof carefully made. The protest of any director, trustee, stockholder, or member on any action or proposed action must be recorded in full on his demand. The records of all business transactions of the corporation and the minutes of any meetings shall be open to inspection by any director, trustee, stockholder, or member of the corporation at reasonable hours on business days, and he may demand writing for a copy of excerpts from said records or minutes at his expense. So gagastos pala si stockholder or board of director o si trustee kung gusto yan ng copy ng minutes. Any officer or agent of the corporation who shall refuse to allow any director, trustee, stockholder, or member of the corporation to examine and copy excerpts from its records or minutes in accordance with the provisions of this code shall be liable to such director, trustee, stockholder, or member for damages, and in addition shall be guilty of an offense which shall be punishable under Section 144 of this code, provided that if such refusal is made pursuant to a resolution or order, saan ako? Of the board, ayun provided that if such refusal is made pursuant to a resolution or order of the board of directors or trustees, the liability under this section for such action shall be imposed upon the directors or trustees who voted for such refusal, and provided further that it shall be a defense to any action under this section that the person demanding to examine and copy excerpts from the corporation's records and minutes has improperly used any information secured through any prior examination of the records or minutes of or minutes of such corporation or of any other corporation, or was not acting in good faith or for a legitimate purpose in making his demand. Stock corporations must also keep a book to be known as the stock and transfer book, in which must be kept a record of all stocks in the names of the stockholders alphabetically arranged, the installments paid and unpaid on all stock for which subscription has been made, and the date of payment of any installment. A statement of every alienation, sale, or transfer of stock made, the date thereof, and by and to whom made, and such other entries as the bylaws may prescribe. The stock and transfer book shall be kept in the principal office of the corporation or in the office of its stock transfer agent, and shall be open for inspection by any director or stockholder of the corporation at reasonable hours on business days. No stock transfer agent or one engaged principally in the business of registering transfers of stocks in behalf of a stock corporation shall be allowed to operate in the Philippines unless he secures a license from the Securities and Exchange Commission and pays a fee as may be fixed by the Commission, which shall be renewable annually, provided that a stock corporation is not precluded from performing or making transfer of its own stocks, in which case all the rules and regulations imposed on stock transfer agents, except the payment of a license fee herein provided, shall be applicable. Section 75, ba't di ko nakikita na yung katabi? Section 75, right to financial statements. Within 10 days from receipt of a written request of any stockholder or member, okay, nag-request yung stockholder o yung member, the corporation shall furnish to him its most recent financial statement, which shall include a balance sheet as to the end of the last taxable year and a profit or loss statement for said taxable year, showing in reasonable detail its assets and liabilities and the results of its operations. At the regular meeting of stockholders or members, the board of directors or trustees shall present to such stockholders or members a financial report of the operations of the corporation for the preceding year, which shall include financial statements duly signed and certified by an independent certified public accountant. However, if the paid-up capital of the corporation is less than 50,000, the financial statements may be certified under oath by the treasurer or any responsible officer of the corporation. Pero wala na sigurong corporation ngayon na may paid-up capital na 50,000. Ito na tayo sa title. Okay. Title 9. Sige, tirahin na natin to. Merger and consolidation. Okay, Section 76, plan or merger of consolidation. Section 76, plan or merger of consolidation. Two or more corporations may merge into a single corporation which shall be one of the constituent corporations, or may consolidate into a new single corporation which shall be the consolidated corporation. Pwede magsama ang dalawang korporasyon. Magiging isa sila. Parang kinasal, no? The board of directors or trustees of each corporation party to the merger or consolidation shall approve a plan of merger or consolidation setting forth the following. Ito yung dapat nakalagay. Number 1, the names of the corporations proposing to merge or consolidate, hereinafter referred to as the constituent corporations. Number 2, the terms of the merger or consolidation and the mode of carrying the same into effect. Number 3, a statement of the changes, kung meron man, in the articles of incorporation of the surviving corporation in case of merger, and with respect to the consolidated corporation in case of consolidation, all the statements required to be set forth in the articles of incorporation for corporations organized under this code. And number 4, such other provisions with respect to proposed merger or consolidation as are deemed necessary or desirable. Section 77, stockholders or members approval. Upon the approval by majority vote of each of the board of directors or trustees of the constituent corporations of the plan of merger or consolidation, the same shall be submitted for approval by the stockholders or members of each of such corporations at separate corporate meetings duly called for the purpose. Ibig sabihin, magtatawag ng meeting para dun nga sa purpose ng merger. Notice of such meeting shall be given to all stockholders or members of the respective corporations at least 2 weeks prior to the date of the meeting, either personally or by registered mail. Said notice shall state the purpose of the meeting and shall include a copy or a summary of the plan of merger or consolidation. The affirmative vote of stockholders representing at least 2/3 of the outstanding capital stock of each corporation in the case of stock corporations, or at least 2/3 of the members in the case of non-stock corporations, shall be necessary for the approval of such plan. So 2/3 pa rin ng outstanding capital stock. Any dissenting stockholder in stock corporations may exercise his appraisal right in accordance with the code, provided that if after the approval by the stockholders of such plan, the board of directors decides to abandon the plan, the appraisal right shall be extinguished. Siyempre, hindi na tuloy eh. So, yung appraisal right mo, it shall be extinguished. Sandali lang. Kanina pa natin nababanggit yung appraisal right. Subukan natin siyang hanapin. Hanapin lang natin appraisal right. Ito, It is the statutory or legal right of a corporation's shareholders to have a judicial proceeding or independent valuator to determine a fair stock price and oblige the acquiring corporation to purchase shares at the price. At that price. An appraisal right is a protection policy for shareholders preventing corporations involved in a merger from paying less than the company is worth to the shareholders. So yun pala ang appraisal's right. Yun yung karapatan ng isang stockholder, okay? Na papatignan niya yung tunay na value ng kanyang stocks para hindi naman siya maagrabyado. Any amendment to the plan of merger or consolidation may be made, provided such amendment is approved by majority vote of the respective boards of directors or trustees of all the constituent corporations and ratified by the affirmative vote of stockholders representing at least 2/3 of the outstanding capital stock or of 2/3 of the members of each of the constituent corporations. Such plan, together with any amendment, shall be considered as the agreement of merger or consolidation. Section 78. Articles of merger or consolidation. After the approval by the stockholders or members as required by the preceding section, articles of merger or articles of consolidation shall be executed by each of the constituent corporations to be signed by the President or Vice President and certified by the Secretary or Assistant Secretary of each corporation, setting forth, number 1, the plan of the merger or the plan of consolidation. Number 2, as to stock corporations, the number of shares outstanding, or in the case of non-stock corporations, the number of members. And number 3, as to each corporation, the number of shares or members voting for and against such plan, respectively. Section 79. Effectivity of merger or consolidation. The articles of merger or consolidation signed and certified as herein above required shall be submitted to the Securities and Exchange Commission in quadruplicate for its approval. So, apat na kopya, no? Provided that in the case of merger or consolidation of banks or banking institutions, building and loan associations, ito na naman sila, sama-sama sila, trust companies, insurance companies, public utilities, educational institutions, and other special corporations governed by special laws, kailangan nila ng favorable recommendation of the appropriate government agency. If the Commission is satisfied that the merger or consolidation of the corporations concerned is not inconsistent with the provisions of this code and laws, it shall issue a certificate of merger or of consolidation, at which time the merger or consolidation shall be effective. So pagka-issue niya, pag sinuri ng SEC, oy, hindi naman pala ito, yung merger ninyo ay alinsunod sa batas. So pagka-issue niya ng certificate of merger or consolidation, effective agad yun. If upon investigation, the Securities and Exchange Commission has reason to believe that the proposed merger or consolidation is contrary to or inconsistent with the provisions of this code or existing laws, it shall set a hearing to give the corporations concerned the opportunity to be heard. Written notice of the date, time, and place of hearing shall be given to each constituent corporation at least 2 weeks before said hearing. The Commission shall thereafter proceed provided in this code. Magtungo na tayo Section 80, effects of merger or consolidation. Number 1, the constituent corporation shall become a single corporation which, in case of merger, shall be the surviving corporation designated in the plan of the merger. Nakalagay naman doon sa merger plan kung sino yung maiiwan na korporasyon. Siya yung surviving. And in case of consolidation, shall be the consolidated corporation designated in the plan of consolidation. Number 2, the separate existence of the constituent corporation shall cease. Mawawala na sila, except that of the surviving or the consolidated corporation. Yung surviving, yun na lang may iwan. Kunwari, nagkambal sa ibang Coca-Cola at saka Pepsi. Nakalagay sa merger, ang maiiwan ay yung Coca-Cola. So, wala na yung Pepsi. Coca-Cola na yung naiwan. Number 3, the surviving or the consolidated corporation shall possess all the rights, privileges, immunities, and powers, and shall be subject to all the duties and liabilities of a corporation organized under this code. Number 4, the surviving or the consolidated corporation shall thereupon and thereafter possess all the rights, privileges, immunities, and franchises of each of the constituent corporations, and all property, real or personal, and all receivables due on whatever account, including subscriptions to shares and other causes and other choices in action, tama ba? Yan? And all and every other interest of or belonging to or due to each constituent corporation shall be deemed transferred na siya to invested in such surviving or consolidated corporation without further act or deed. And ikalima, the surviving or consolidated corporation shall be responsible and liable for all the liabilities and obligations of each of the constituent corporations in the same manner as if such surviving or consolidated corporation had itself incurred such liabilities or obligations. So kung kunwari, yung example ko kanina, nagkambalsanib, nag-merge ang Coca-Cola at Pepsi, nakalagay sa kanilang certificate of merger na naiwan ng Coca-Cola. So lahat ng mga receivables ng Pepsi, lahat ng mga obligasyon ng Pepsi, lahat ng property nila, mapupunta na yun doon sa naiiwang korporasyon, which is, in our example, yung Coca-Cola. Sabi rin dito, and any pending claim, action, or proceeding brought by or against any of such constituent corporations may be prosecuted by or against the surviving or consolidated corporation. So kung may kaso yung Pepsi at nag-merge sila ni Coca-Cola, naiwan si Coca-Cola na rin ang kalaban mo sa kaso. The rights of creditors or liens upon the property of any of such constituent corporations shall not be impaired by such merger or consolidation. Ang pagsasama ng dalawang korporasyon ay hindi nito maaharangan o hindi nito matatabunan yung mga dating obligasyon at yung mga hinahabol ng batas o kung ano pa man dun sa lumang, yung sa nag-merge na korporasyon. Okay? So malinaw yun, class. Charot. So dun tayo nagtatapos sa section 80 ng Corporation Code. Pagod na ako. Medyo hirap na hirap ako sa corporation code na ito dahil ang liit ng letters, so ang hirap basahin. But anyway, nais ko magpasalamat sa inyong pagsama sa akin at mag-pray muna tayo. Our Father in heaven, holy be your name. Your kingdom come, your will be done on earth as it is in heaven. Give us this day our daily bread and forgive us our sins as we forgive those who sinned against us. Do not bring us to the test but deliver us from evil. Amen. Maraming salamat po sa pagsama sa akin, sa aking pagbabasa ng mga batas. At sinusubukan natin itong ipaliwanag in layman's term. God bless.